The Supreme Court has delivered a judicial ruling of such magnitude that it has fundamentally destabilized Donald Trump's legal position, sending the former president and his entire legal apparatus into a state of profound disarray. We are witnessing a historic inflection point that virtually no observer anticipated, and the ramifications for Trump's defense strategy are nothing short of catastrophic. In a decision that legal historians and constitutional scholars are already characterizing as unprecedented in American jurisprudence, the Supreme Court has ordered Donald Trump to immediately surrender financial records, internal business communications, and sensitive documents that even his own counsel did not realize were under active investigation. This was not a routine procedural dismissal. This was the nation's highest court removing a protective barrier to expose concealed evidence. A sealed grand jury investigation has been operating covertly, running parallel to every known prosecution for more than 12 months. Trump is now legally compelled to hand over evidence that could reveal an entirely new dimension of criminal exposure previously hidden from public view. What makes this particularly extraordinary is that the Supreme Court managed to maintain complete secrecy around proceedings of this magnitude for an extended period. We are discussing a clandestine legal process conducted entirely outside public awareness, a hidden judicial battle that even Trump's lead defense attorneys were reportedly unaware of until the decision was announced. The justices released this ruling without advance warning, without televised oral arguments, without media briefings, and without any opportunity for Trump's communications team to shape the narrative or for his legal team to prepare a counter-strategy. One moment, Donald Trump believed he had mapped every legal threat surrounding him. The next moment, the foundation collapsed beneath him, revealing a legal vulnerability he did not know existed. This is not simply another case added to his growing list of legal challenges. The Supreme Court has disclosed that a covert investigation has been active the entire time, involving evidence so sensitive or potentially damaging that even the existence of the subpoena had to remain classified. The implications of this revelation are poised to fundamentally reshape everything we understood about Trump's legal exposure and political future. To fully appreciate the gravity of this surprise ruling and why it has generated such disorder, it is essential to understand how extraordinarily rare this type of Supreme Court action is. Under normal circumstances, the court operates at the apex of transparency. Cases appear on public dockets where anyone can track them. Oral arguments are scheduled months in advance, allowing preparation time. Briefs are filed openly for journalists, academics, and the public to examine. Secrecy is typically absent from Supreme Court proceedings. However, the court does possess authority, in exceptionally rare and narrowly defined situations, to conduct proceedings entirely under seal. This power is reserved for moments when national security is at risk or when other extraordinary interests require complete confidentiality. Historically, this authority has been used sparingly, generally limited to matters involving classified intelligence, active national security operations, or circumstances where public disclosure could cause immediate and irreversible harm. The fact that the court invoked this power speaks volumes about the seriousness of what is at stake. According to the ruling released on December 7th, this sealed process began more than a year ago when a grand jury issued a subpoena demanding Trump's financial records, internal business communications, and documents related to what the opinion vaguely describes as matters of significant national concern. Because the subpoena was issued under seal, Trump was served while simultaneously being placed under a gag order. He was legally prohibited from revealing its existence to the public, his political supporters, or the press. His attorneys were bound by the same strict confidentiality requirements. Here is what makes this story almost unbelievable. Trump fought the subpoena through sealed legal filings, advancing the same arguments about immunity and executive privilege that he has loudly asserted in public courtrooms. He relied on his familiar legal playbook, but those arguments failed at every level. The case progressed through the federal court system entirely outside public view. The lower court rejected his claims. The appellate court rejected them as well. Now the Supreme Court has rejected them in a final, unequivocal ruling that both exposes the existence of this hidden battle and orders immediate compliance. The opinion, authored by Chief Justice John Roberts, is direct and uncompromising. It states that the subpoena seeks documents related to conduct that falls completely outside any plausible claim of presidential immunity. It further explains that the defendant's attempts to delay and obstruct compliance have been fully exhausted through appropriate legal channels, and that no additional delay will be permitted. Legal experts analyzing the ruling note that its language suggests this investigation is entirely separate from the classified documents case in Florida, separate from the January 6th prosecution in Washington, and separate from the Georgia election interference case. This appears to be a distinct and independent legal front, effectively a fourth major battlefield that opened beneath Trump without the public ever realizing it existed. This is not the first time the Supreme Court has ruled against Donald Trump. He has suffered defeats before. What makes this ruling fundamentally different is the element of total surprise and the revelation of this hidden dimension. When the court rejected his claims of absolute immunity earlier this year, his legal team anticipated the outcome. The case unfolded publicly. They had months to prepare alternative arguments and media strategies. That ruling was damaging, but it was expected. When the court ruled in 2020 that Trump's tax returns could be obtained by New York prosecutors, there was no shock. That legal battle had played out publicly for years, giving his attorneys time to prepare responses and anticipate consequences. Even the historic Watergate decision in United States versus Nixon, which forced the president to surrender the White House tapes, followed prolonged public litigation. Richard Nixon knew the case was coming, understood what was at stake, and had time to consider his options, including resignation. This ruling is structurally different. Trump's team had no awareness of this sealed proceeding reaching the Supreme Court in this form. They had no opportunity to prepare for this outcome. They began the day believing they understood the full scope of Trump's legal problems. By midday, they learned that belief was false. According to reporting from the New York Times on December 7th, Trump's lead attorneys learned of the ruling through breaking news alerts rather than direct notification from the court. The sealed nature of the process meant even standard procedural notices were restricted. One source described the atmosphere at Mar-a-Lago as utter chaos, with lawyers scrambling to determine which documents were covered by the subpoena and how quickly compliance was required. This brings us to Trump's usual response pattern. When he faces setbacks, he attacks. When the immunity ruling was issued, he criticized the justices. When lower courts ruled against him, he filed immediate appeals. When damaging evidence surfaced in the classified documents case, he claimed it was fabricated. His strategy has consistently been to attack, delay, and delegitimize. This ruling leaves almost no room for that approach. The subpoena has already been litigated through every level of the federal judiciary. The Supreme Court's decision is final. There are no further appeals available. There is no higher authority. The ruling specifies a compliance deadline of exactly 72 hours from its release. This is not a matter of weeks or months. It is 3 days. The court included an extraordinary warning. The opinion states that any failure to comply fully and in good faith will result in immediate civil and criminal contempt proceedings, with penalties that could include pre-trial detention. The court is effectively warning that any attempt to delay, obstruct, or provide incomplete responses could lead to incarceration before trial. This language reflects a judiciary that has exhausted its patience. The justices have watched Trump attack judges, ignore court orders, and treat the legal system as a political stage. This ruling signals that such behavior will no longer be tolerated. So what exactly does this sealed subpoena demand? And why has Trump's legal team descended into crisis? The answer lies in the extraordinary breadth of the document requests. According to excerpts included in the now public ruling, prosecutors are seeking 3 major categories of evidence. First, they demand complete financial records from Trump's business empire dating back to 2015. This includes every transaction involving foreign entities, all loan agreements and their terms, and all communications related to property valuations. These records directly implicate long-standing allegations of financial fraud and potential money laundering that have followed Trump for years, but have never been conclusively proven in court. Second, prosecutors are demanding all communications between Trump and specific foreign nationals whose identities remain redacted due to national security concerns. This goes beyond routine business dealings and suggests potential interactions with foreign governments or intelligence-linked individuals. Analysts speculate this could involve anything from dealings with Russian oligarchs to undisclosed communications with foreign officials during or after Trump's presidency. The third category is potentially the most explosive. The subpoena seeks documents related to efforts to obtain things of value from foreign sources in connection with electoral activities. This language closely mirrors federal statutes that prohibit foreign contributions to United States political campaigns. This suggests investigators may be examining whether Trump or his campaign solicited or accepted illegal foreign assistance, an allegation that strikes at the core of democratic integrity. This is where Trump's defense faces an almost impossible challenge. These document requests overlap with existing cases but extend far beyond them. Financial records may relate to known civil fraud matters but could also expose entirely new misconduct that has not yet been charged. Foreign communications may intersect with prior investigations, but the national security classification implies something far more serious. Trump's attorneys have only 72 hours to gather and produce documents spanning nearly a decade of complex business and political activity. They may not even know where all relevant materials are stored. They must review potentially millions of pages for privilege issues, while knowing the court has made clear it will accept no delays. Sources speaking to Politico on December 7th reported that Trump's legal team convened an emergency meeting within hours of the ruling to confront what one attorney described as an impossible task. The volume of documents is overwhelming. The timeline is brutally short, and the penalty for failure is imprisonment. Yet the logistical challenge is only part of the danger. The real threat lies in what these documents may reveal. Whatever Trump worked so aggressively to conceal through a year of secret litigation is now on the brink of exposure. The extraordinary secrecy surrounding this investigation strongly suggests prosecutors believe the evidence is devastating. According to multiple reports, including coverage from CNN and MSNBC, Trump's reaction to the ruling was explosive. Sources describe him yelling at his attorneys, throwing objects, and demanding to know who allowed this hidden proceeding to progress without stopping it. There was no betrayal. His lawyers fought the subpoena and lost at every level in proceedings they were legally barred from discussing publicly. The secrecy Trump often uses to control narratives turned against him. He could not rally public support for a fight the public did not know existed. Predictably, Trump escalated the situation. Within hours, he posted on Truth Social, attacking the Supreme Court justices, including those he appointed. He labeled the ruling a covert assault by corrupt judges, suggested that Chief Justice Roberts was compromised, and declared the entire proceeding unconstitutional, explicitly stating that he would not comply with what he described as an illegitimate order. Legal experts immediately raised serious concerns, warning that these statements could be used as powerful evidence demonstrating an intent to defy a lawful court order. If Trump follows through on his threat to refuse compliance, prosecutors can cite these social media posts as clear proof that his non-compliance was deliberate and intentional, rather than the result of logistical difficulties or good faith disputes over the scope of the subpoena. According to former federal prosecutor Andrew Weissman speaking on MSNBC, Trump's public remarks amount to a written invitation for contempt proceedings. Weissman explained that when a defendant openly announces an intention to defy a Supreme Court order, prosecutors do not need to struggle to establish intent. The defendant has already admitted it publicly. This situation places Trump in a position where every possible outcome leads to serious consequences. If he complies with the subpoena and turns over the documents, he provides prosecutors with evidence that could expose entirely new areas of criminal liability. Whatever he has been concealing is about to become part of the official record. If he refuses to comply, he faces immediate contempt proceedings. The court has already warned that potential sanctions could include pretrial detention. Trump could find himself in a jail cell, not because of the crimes he has been charged with, but simply for refusing to obey a lawful subpoena. That would be an extraordinary spectacle, a former president imprisoned for contempt while multiple criminal trials remain pending. If he attempts to stall through procedural maneuvers, the 72-hour deadline makes that strategy nearly impossible. There is no time to file new motions. There is no time to pursue new appeals. The Supreme Court has issued its decision. The matter is closed. Compliance is mandatory. It is a trap with no escape, and it is entirely of Trump's own making. Whatever those documents contain, he could have surrendered them a year ago when the subpoena was first issued. Instead, he challenged it at every level and lost each time, wasting time and resources while the evidence remained out of prosecutors' reach. Now he has no viable options remaining. This entire situation is sending shockwaves through Trump's political and legal circles because the disclosure of this secret proceeding raises alarming questions about what else might be unfolding behind the scenes. According to reporting from the Washington Post on December 7th, Trump's allies are in a state of near panic, attempting to determine whether there are other sealed proceedings of which they are unaware. If one confidential investigation could reach the Supreme Court without public knowledge, why could others not exist as well? What additional matters might the Department of Justice be pursuing that have not yet been revealed? This uncertainty is psychologically devastating to Trump's defense strategy. For months, his attorneys have structured their plans around the cases they believed were known: classified documents, January 6th, Georgia and New York. They allocated resources, crafted strategies, and coordinated timelines under the assumption that they understood the full extent of Trump's legal exposure. They now realize that assumption was dangerously incomplete. The situation grew even more chaotic when reports emerged that at least 2 attorneys on Trump's legal team are considering withdrawing from the case. According to sources who spoke with CNN, these lawyers were not fully informed about the sealed proceeding due to strict confidentiality requirements. They are now questioning whether they can ethically continue representing a client who may have withheld critical information from them or placed them at risk of ethical violations. Attorney withdrawal at this stage would be disastrous. New counsel would require months to familiarize themselves with the case, and the 72-hour compliance deadline does not pause for staffing changes. Trump's already damaged standing within the legal community also means that finding qualified replacements would be extremely difficult. Meanwhile, the attorney who previously cooperated with prosecutors, the individual who provided leaked audio recordings, is reportedly offering additional context regarding the sealed subpoena. According to sources familiar with the matter cited by Politico, this cooperating witness has specific knowledge of documents Trump attempted to conceal and can testify about conversations in which Trump discussed the consequences if those records were ever made public. If this information is accurate, it means prosecutors possess more than subpoena authority. They have a detailed roadmap. They know precisely what to search for. They can compare what Trump ultimately produces with what the cooperating witness states should exist. Any missing materials or suspicious gaps will be immediately obvious. This leads to a broader question about what this surprise ruling means for Trump's actual legal exposure, because its implications extend into areas that have not been publicly explored until now. First, the demand for extensive financial records suggests prosecutors are constructing a case that goes far beyond existing fraud allegations. The New York civil fraud case focused on inflated property valuations for loan and tax purposes. However, the scope of this subpoena, reaching back to 2015 and covering all foreign transactions, indicates a deeper line of inquiry. Legal analysts are speculating about potential money laundering, unreported foreign income, or violations of the Foreign Corrupt Practices Act. According to tax law experts who spoke with CBS News, the breadth of the financial records request is extraordinary. They noted that prosecutors usually narrow subpoenas to specific transactions or defined timeframes. Requesting everything since 2015 involving foreign entities suggests an effort to identify patterns of systemic behavior rather than isolated acts. Second, the demand for communications with redacted foreign nationals raises the specter of counterintelligence concerns. The court's reference to national security interests as justification for keeping these names sealed is not routine language. It implies that these individuals may be linked to foreign intelligence services or could themselves be subjects of ongoing national security investigations. Some legal observers are connecting this development to long-standing questions about Trump's relationships with foreign governments, his unusual deference toward Vladimir Putin, his private meetings with foreign leaders without the presence of American officials, and his handling of classified information in discussions with foreign nationals. These issues have never been fully resolved, and this subpoena may finally produce documentary evidence capable of answering them. Third, the reference to obtaining items of value from foreign sources in connection with electoral activities suggests an investigation into campaign finance violations on a scale far beyond anything previously disclosed. Federal law strictly prohibits foreign nationals from contributing to United States political campaigns, and it also forbids campaigns from soliciting or accepting such contributions. If Trump or his campaign received foreign financial assistance, that constitutes a serious federal offense. According to campaign finance experts interviewed by MSNBC, the specific language used in the court's ruling closely mirrors the statutory prohibition itself. They emphasize that prosecutors do not choose such precise wording accidentally. It indicates they may already possess evidence of potential violations and are seeking documents to confirm or expand the case. Taken together, these three areas, financial records, foreign communications, and evidence of possible foreign campaign support, paint a picture of an investigation far more severe than Trump's existing criminal cases. This is not merely about mishandling documents or openly attempting to overturn an election. It involves potential corruption at the intersection of money, foreign influence, and American democracy itself. Legal scholars are already assessing the constitutional and historical significance of this moment. Lawrence Tribe, the prominent Harvard constitutional law professor, stated on social media that this ruling may represent the most consequential Supreme Court decision involving a former president since United States versus Nixon. He observed that although the confidential procedure represents an extraordinary measure, it appears to be justified by matters of national security that we may not fully understand for an extended period. However, what truly captured attention was this particular element. Conservative legal analyst Jonathan Turley, who has frequently supported Trump through media appearances, went on Fox News and acknowledged that this decision presents what he termed an existential crisis to Trump's legal circumstances. Turley emphasized that the presence of confidential proceedings indicates prosecutors possess evidence of activities sufficiently serious to warrant extraordinary secrecy measures. This represents an unfavorable development for Trump, considering that even sympathetic legal professionals cannot discover a means to reduce the negative impact. You recognize you are witnessing something momentous when the defense's typical defenders find themselves without adequate responses. Let us examine what this unexpected court ruling signifies for the direction of American democracy, because it addresses not merely Trump's individual legal troubles, but carries substantial consequences for how we view presidential accountability, safeguarding the nation, and respect for legal systems. Initially, there remains the pressing matter of what these records will disclose. Should Trump conform to the court order, legal authorities will obtain access to materials that remained concealed from general knowledge for an extensive period. Such materials could fundamentally change our perspective of Trump's time as president, his commercial operations, and his associations with international governments. It could furnish responses to concerns that have troubled American government since 2016. However, the disclosure method will face complications. Certain information is apparently confidential or involves matters related to protecting the nation. Legal professionals may be authorized to introduce it during judicial proceedings while preventing it from being released to the general public. The general population may never access the complete picture of these records' substance. We may have to depend on judicial determinations, formal charges, and subsequent courtroom declarations to comprehend what remained unknown. Next, this decision creates vital established legal rules applicable to forthcoming situations concerning sitting and previous leaders. The judicial body has now clearly indicated that confidential jury discussions can arrive at the Supreme Court and generate binding judgments against previous leaders. They have shown that assertions of protected authority and presidential powers, even when fought with determination, will finally be defeated when the sought material pertains to non-presidential actions. This carries weight because upcoming leaders will understand that their deeds can be researched in confidence, that their court arguments can be settled away from public attention, and that adherence can be enforced promptly after legal choices are finished. The era of using public attention and stalling tactics as primary defensive measures is approaching its termination. Subsequently, the safeguarding national security elements of this decision generate critical inquiries regarding what our governmental security organizations understand concerning Trump that ordinary residents do not know. The presence of the confidential court sessions indicates knowledge so delicate that merely disclosing that an examination exists would generate injury. What do prosecutors possess knowledge of? What have national safety organizations uncovered? And what length of time have they possessed this knowledge? These inquiries may remain permanently unanswered, or at minimum never become public information. Yet they emphasize the significance of this instance. We are not only examining a previous leader receiving criminal allegations. We are examining possible hazards to national protection that necessitated confidential judicial processes to manage. Considering the governmental aspects ahead, the judgment generates substantial unpredictability. Trump presently occupies the primary position for the Republican Party's leadership selection. He campaigns centered on opposing the corrupt institution allegedly attacking him. However, this judgment demonstrates that the institution has examined him in manners he failed to recognize, and that examination has currently achieved a level where obedience is required. What will Trump's supporters' reaction be? Certain individuals will consider it proof of persecution by an underground governmental force functioning covertly. Still, others might begin asking themselves what their hopeful leader has concealed. What creates such destruction that he battled a confidential court struggle entirely toward the Supreme Court to maintain it hidden? In accordance with latest information from YouGov, a substantial percentage of residents, comprising an increasing proportion of Republican voters, conclude Trump must be required to obey legal requests for records irrespective of whether the materials may be incriminating. The concept that each individual complies with the law maintains its strength, particularly with those supporting Trump electorally. The Democratic Party will undoubtedly leverage this judgment to strengthen their assertion regarding Trump's inadequacy for executive authority. They will contend that a contender who secretly opposed revealing materials to prosecutors cannot be granted executive authority. Thus, this represents the situation. The Supreme Court has just unveiled that a classified jury examination has been researching Trump for beyond a calendar year, absent public recognition. They determined that Trump must provide materials requested in a legal demand regarding monetary accounts, worldwide connections, and materials concerning possible worldwide participation in voting procedures. Provision is essential within 72 hours. Disobedience will result in legal punishment and probable incarceration. Trump experienced total astonishment. His attorneys were uninformed this judgment was approaching. His governmental organization lacked the opportunity to formulate a tactical response. Additionally, the dimensions of the legal demand propose prosecutors are examining behavior significantly more severe than the recognized public situations. This represents the judicial form of an unexpected assault. Trump invested a year combating in privacy and failed at every judicial point. Presently, he cannot take any additional measures, provide and release probably harming materials, or challenge and experience jail for breaking legal obligations. In either scenario, anything he has maintained concealed is about to surface. The 72-hour clock is currently functioning. Right now, prosecutors remain expecting. The population is watching. Additionally, Donald Trump encounters the maximum dangerous period of his courtroom circumstances, a period he did not anticipate. Pay close attention to these developments. The approaching 3 days will establish if Trump follows instructions or opposes, if he furnishes materials or experiences incarceration for breaking legal obligations, and if the confidential information he has maintained finally becomes apparent. We observe a previous leader constrained by the nation's supreme judicial authority, without further retreat opportunities, and without more appeals remaining to submit. Uncertainty has achieved its highest level. The available duration has become shortest, and the consequence has never carried more importance for the continuation of democratic America. No matter what the materials include, no matter what Trump has been earnestly attempting to maintain hidden, we are about to become aware. This represents the decisive period, and it is arriving quicker than anticipated.